Robert, how's everything going with you?
Good, good. I think that it was interesting watching some of the Trump news yesterday. It's the ability of people to get the law wrong is always striking. Now, it's not a surprise the left does so. The left does so deliberately and malevolently and maliciously, but even some allies on the right, and it's mostly because they don't know that much about the federal criminal justice system, and so the ones that have the right intentions but have the wrong interpretation. So the Justice Department put out a brief in which they referenced that they had subpoenaed uh, the impression was left that they had subpoenaed Trump, that Trump had only turned over certain information, said it was everything, and then they found more. So the suggestion was perjury and obstruction, etc. If you know how these subpoenas work, you knew that was unlikely. I got to look at the actual subpoena, and it's not what the media was representing. So the subpoena was issued to the office of Donald John Trump, to a specific entity. There's reasons why they did that. And the responder was the custodian of records for that entity. And the custodian said, this is the records that I, as custodian for this entity, have in my possession at this time that are relevant to your subpoena. Then when they do a search of Donald Trump's personal residence, they find other documents. There is no necessary contradiction whatsoever between those two events. In fact, you would typically find more documents in searching an individual's personal residence than you would a corporate subpoena to a corporate entity for custodial records at that time. The reason the Justice Department was playing that game using the D.C. grand jury, it's absurd that we have a grand jury on this in the first place, but putting that aside, is because if they had subpoenaed Trump personally, then Trump or an entity that would be so affiliated with him as to be the equal to a personal subpoena, then he can assert personal objections, including First Amendment selective prosecution, especially Fifth Amendment right not to be a witness against yourself, and the presidential privilege. They chose to avoid all of that by subpoenaing a limited entity for those documents. And even though the subpoena said, give us everything Trump has, that you can't do that by subpoenaing somebody else. Be like them subpoenaing you, Viva, and saying, give us everything Barnes has. You don't have custody of everything Barnes has. So they're doing it to get around the objections that Trump would have as an individual. That comes with a catch. The catch is you don't get everything because the custodian is only a custodian of records for that particular entity that he has in his physical possession at that particular time that the subpoena was served. And my guess is the idea that the lawyer lied and that they hid that's just preposterous, quite frankly. They were playing games with a subpoena. Trump responded in kind. And what this all is further confirmation of is under the guise of this being an archive search, this is simply Trump took deep state docs with him that are embarrassing to the deep state. They've been obsessed with getting him back. They tried to get him back through the archives. Then they tried to get him back through the subpoena. Then they tried to get him through the search. And my guess is by their reaction, they didn't find him any of the three times. They got other docs, but they're not the deep state docs they're looking for.
They got his passport.
Two other components that keep getting misinterpreted somehow. The president, this has been established law. I had these trolls from all the way back to the Alex Jones trial, the people that love the plaintiffs in that case, or hate Alex Jones, is really what they're about. Is they're saying, oh, you don't understand, Barnes, the Presidential Records Act determines what's presidential records, not the president. Apparently unaware that this has already been litigated, already been adjudicated, already been resolved, and by one of their favorite Democratic liberal federal judges. So a president gets to unilaterally declare what is a presidential record or a personal record. If it's a personal record, it's not governmental record, period, end of story. The Justice Department lied today in their opposition brief to the special master's appointment, claiming that those records were presidential records by law, and no, they're not. They're personal. They're whatever Trump says they are. End of story. And then secondly, the people still regurgitating the classified stuff, as even the pro-Democrat lawyers are admitting everything that was subpoenaed, everything that was searched was for things labeled classified, not actually classified documents, which means the search warrant never should have been granted. The subpoena never should have been issued, so on and so forth. This is another reminder that Trump's lawyers have been given bad advice. This is what happens when you cooperate. When you assume the government's operating from good intentions, they use it against you over and over again. This is why it's bad. You could have told them to shove off from day one. It's what Clinton did. It's what Obama did. It's what Trump should have done. And then he wouldn't even have to deal with any of this nonsense. But one last point is people are saying, oh, an indictment is imminent of Trump. Aside from the fact they're not going to indict him right in the middle of the midterms, it violates internal DOJ policies, a bunch of reasons. I don't think they ever plan on indicting him on this because they don't want to tell the world what they're really looking for anyhow, and they don't have legal grounds to do so. Doesn't mean it's impossible that a DC grand jury goes off and does something rogue. It's DC. It's a rogue legal system to begin with, so that's always possible, but it's not probable because they don't have a criminal case. But the best evidence of that is if the Justice Department thought they had Trump dead to rights on obstruction of justice, they never put this in the brief. They entrap other people connected to the case in interviews without them knowing what they have and snare them. And instead, they just gave a clean roadmap to Trump to know exactly where they were even trying to go. This, by the way, is information they redacted in the search warrant affidavit because it was so necessary. And a week later, they disclose it when it's convenient for them. Again, showing how that judge was a fraud by delegating to the government the decision to redact. But the government was a fraud by claiming this was compelled to be redacted when they disclosed it 1 week later, some of this information. But the fact they're disclosing it means they know they don't have a criminal case. It's solely meant in the court of public opinion because it has nothing to do with a special master. It has zero to do with a special master. Whether Trump did or didn't do something in response to a subpoena has zilch to do with whether a special master should be appointed. It's purely for the court of public opinion. So that's the snapshot on that little issue that people were talking about.
And I don't know if we're going to get into it more in detail tonight. I think we've got probably more Russia-oriented, Joe Biden-oriented discussion. But if we get into it, it'll be tonight. And if we don't, it will definitely be on Sunday, Robert.
Yes.
But, I know people were asking those questions. Jackson Hinkle, sir.
It's good to be here.